Hey again, everyone. It's Rob Ryder on December 9th, 2013. That would be a Monday. Lots of different things to talk about. Really hard anymore to put it into a category and say, oh, I'm going to do a video on this because there's this over here and this over here and this went back over here. And so this is kind of a compilation of lots of different things, but basically it's based on a lot of it on the video I did last week. So, don't remember the name. It was special proceedings equal prerogative writs, I believe, or something like that. If you were to put in the word special proceeding on my YouTube site, which is Rob Ryder with 3 B's, ROBBBRYDER, you'd see there's 3 different ones where I talked about special proceedings, really using the same form or the same self-help guide. Each time maybe understand a little bit better and maybe not. But what it is special proceedings, or some places like in Arizona they're called special actions, and what it is where you are, I don't know yet. But what it does, it's the vehicle that you use to get a prerogative writ. And those were writs of the king. And the reason we want writs of the king, because then we're dealing with the royal courts instead of the franchise courts. Right now we seem to find ourselves in franchise courts, and they don't really seem to care what we do. They just say we're not following a procedure. Well, there's a particular way to get from the franchise court into the king's court. And, this shit didn't just start happening. It's been this way for hundreds of years, all the way back to the time of the Magna Carta, which is the Constitution of the Jewry, Constitution between the Jews and the King of England. And prior to the Magna Carta, another contract they had with one of the other kings of England was to make all the Jews the king's property. Right? So now the Jews were the king's property. They had the king's protection. And part of that was they got to have their own courts. Well, now they have these own courts. If you go in there as a Christian, you have to play by their rules. And because they were the king's property, it never frickin' fails, and had the king's protection, if you had a complaint, you had to go to the king's officer. And the king's officer, right, would be a royal officer. And that's where you would take your complaint to. So that's what we're trying to do, is get to that level of jurisdiction. And so, okay, so let's just start with what this said. This came off the self-help guide for doing a special proceeding, which is called a Rule 78 or Section 78, don't really remember, out of New York. New York law requires that papers commencing a special proceeding must be filed with the county clerk. Now, see, that's the unusual part. Who would think you go to the county clerk first to file something? Do with a court case. Apparently you do. And that an identifying number, an index number, be obtained. So you're going to go there and you get an index number. The petitioner should go to the county clerk's office. The petitioner will have to fill out an index number cover sheet form and purchase an index number from the cashier. The petitioner must write in the index number assigned by the county clerk in the index number space to the right of the caption on each of the documents prepared by the petitioner. Right? So you're going to get the index number, and now you need to write it into all your pieces of paper to the right of the caption. A copy of all these documents must be filed with the county clerk, who will open a court file for the case. The clerk will stamp the petitioner's copy to show the papers were filed and will issue a receipt for the purchased index number. Right, so this is all the things you do at the clerk's office, the county clerk's office first. You're going to go buy an index number, and they're going to open up a court case. Again, who would think that the county clerk opens up court cases? Now, I don't know if people in New York, maybe you guys know this, right? But to me, if the system in Michigan is anything like your system, and that's what I'm trying to determine, while everything is different, it's really all the same. So however it works in New York, because Michigan's laws were based on New York, how would it work here? How would it work in some other state? Well, this is so this is what you need to find out. You need to be looking to find out how you apply for like a prerogative writ, such as a writ of mandamus, a writ of certoria, writ of quo warranto. Those are the prerogative writs. So the king's writs, they can only come from the king's court. And those are the original writs. And the thing about original writs, our original writs are applied for in the Court of Chancery. And that's what we're really trying to figure out, is where in the hell they put the Court of Chancery, because that's where you get justice. It's the Court of Justice. So, a copy of all these documents must be filed with the county clerk, who will open the court file in the case. Got all that? Okay, da-da-da-da-da. The clerk will stamp the petition copy, show the papers are filed, and will issue a receipt for the purchase the index number. Keep your receipt. At this point, a filing with the county clerk has been made, but filing with the court has not yet occurred. You're not quite done. The petitioner should next proceed to the Supreme and County Court Clerk's office. County Court. Interesting. We need to find the county court. This is the Supreme and County Court Clerk's office. One thing about the county courts, back in the day, they were the original probate courts, as far as being the ordinary, right? And they still are. And the county courts were also the courts of naturalization. It's where you would go to take your oath to get your citizenship papers. So in a lot of ways, the county court is actually as much a federal court as it is a state court or county court. So when they say small d district court, I think they mean the county court. When they say small d district for federal, I think they mean the county court de jure within a state. Doesn't matter if they do or not. I don't need it for that right now anyways. I'm just saying. One reason I want to find the county court is that's where you would go, take your oath of allegiance, and get your citizenship papers to be a citizen of the United States of America instead of a U.S. citizen in the corporate. Right now, we're just Native Americans. We don't have any citizenship papers anyplace. We're foreigners. The petitioner should next proceed to that court, right? County Court Clerk's office. The original petition in order to show cause. Now, what's an order to show cause? Well, that's what a subpoena is. Now, I cut and pasted this out of the document from last week, so there's parts that are missing. But first of all, we're doing it with a petition, right? We're not doing a civil action. This is a petition we're putting in, and there's going to be an order to show cause. An order to show cause is a subpoena. Must then be presented to the clerk of that office together with proof of the previous filing that you've taken to the county clerk, proof that you bought the index number, and completed some RJ1 form together with a certified check, money order for $95 payable to the office of the county clerk. So the question is, right, am I going to walk into a room that says on the door, Supreme and County Court Clerk's office, or am I going to walk into a room that says office of the county clerk? Because, I'm going to the Supreme and County Clerk's office and we're giving them a check for $95 payable to the office of the county clerk. If you're in New York and you do this, find out, is this the office of the county clerk? Right? Where are you when you're actually paying this, right? Somebody tell me if you go do this, right? And you may want to, and I'm going to show you why here in a minute. Okay, the clerk's going to review your petition's paperwork. So you're not a plaintiff, now you're a petitioner. A plaintiff goes with a plaint, and a plaint was only used in cases having a value of no more than 40 shillings. Right, so we're not a plaintiff of a plaint, we're a petitioner on a petition. If emergency relief is requested, the petitioner must also submit an emergency affidavit which briefly explains the nature of relief requested and why immediate emergency relief is needed, such as you may need to have a temporary stay in an ongoing court case until your writ of certoria has been processed for the higher court to take superintending control of the lower court because the lower court just doesn't seem to understand when you tell them that there's no sworn complaint against you, right? That maybe there's a problem. Well, in that franchise court, they don't care. They told Bobby, we don't care if we don't need to have a sworn complaint. In the jurisdiction he was being charged in, they don't need to have a sworn complaint. That's what they say. Now, they may be a franchise court, but they're supposed to follow their franchise, which, technically is the Constitution and the laws. And if they don't, then you need to take them to the King's Court for superintending control, which are the superior courts. And the courts that have writs of mandamus and certiorari and quo warranto prerogative writs, that's the King's Courts. And all original writs are issued out of the Court of Chancery. And according to the chancellor in a chancery court in Tennessee in 1907, who wrote a book that I've done a couple of videos with, and it says in his book that to defy the Court of Chancery shall rain the thunderous wrath of the Vatican upon you. So somebody's not playing around. So, yeah. And if you can you donate? Not only can you, will you donate? It's been a rough few months here. And I want to thank those that have donated, but to be honest, I ain't got no fingernails left, man. I've been hanging up on my nails. If you can help, I really would appreciate it. My PayPal account is ashleyritluski@gmail.com. Or you can send it by mail to Robert Ritluski, 10955 14 Mile Road, Rockford, Michigan, 49341. And Rob Ryder's email is courtofrecord@aol.com. 616-712-6179 is how you would get a hold of me on the phone. Okay, so this is one way that it was done, right? And they had a self-help guide. So first of all, I don't know that we need to know how to do this. You could, if you were hiring an attorney, if you've hired an attorney and say you're in a foreclosure or something, have him do it. And if he refuses to do it, tell him you want him to fill out the paperwork for a special, you should know what it is first, special proceeding, special act, whatever. Show him where it is in the law. I want you to do one of these. I want you to get a writ of mandamus issued to compel somebody to do or not do something, which is what a writ of mandamus is. And so what is it we're talking about? Well, there's a thing called specific performance on a contract. And, we may want to have specific performance of a contract done, that somebody's refusing to do their part of a contract. Well, that would be compelling a public body to do something. And so you put in this application, which is basically your petition, your complaint, right? And if you watched the video before, you can go download these self-help guides offline. But, see what you need to do for your petition. But at the end of the day, you're petitioning with a complaint. And the complaint is to get superintending control of a situation or compel somebody to do something, specific performance, with a subpoena. And the subpoena then is going to give them 20-some days to answer. And when that's been issued, what the court's going to do, in my opinion, is they're going to pick up the phone and call somebody and say, look, you want to come and handle this now, or do you want us to actually issue this writ and come and get you? And, that hopefully it brings them into the court and they settle up. Only one way to find out, right? We need to go try. It's always that way. What do I want to go to next? Okay, so here's an example of why we might want to use this, or how we might use this. But what I need to do first is I need to pause just for... Alright, back at it. So here's a policy of title insurance. Yeah, anybody who's bought a house probably has one of these. And on here, it basically gives you the owner's coverage statement, covered risk. Your insurance is limited by all the following. Our duty to defend against legal actions, right? They have a duty to defend your title. And we'll see in a minute what kind of title you have, but here are some of the things that are covered. Someone else owns an interest in your title. It seems to be the case because our warranty deeds are being used as implied trust because somebody else paid the $10, and you may have paid the other valuable consideration, but somebody else paid the $10 because they'll never tell you you did. They're going to tell you it's done by custom. So you have a partner that you don't know about it, and so somebody else believes they have an interest in your title from a secret trust. That's what an implied trust is. It's a secret trust or a half-secret trust. As it turns out, they have both of them. Someone else has rights affecting your title arising out of leases, contracts, or options. Right, so somebody else believes, for these reasons, that somebody has rights in your shit. Someone else claims to have rights affecting your title arising out of forgery or impersonation. Someone else has an easement on the land. Someone else has a right to limit your use of land. Your title is defective. Any of the risk 1 through 6 covered after the policy date. Right? So 7 says any of the covered risk after the policy date, it will cover. Then 1 through 6 must be for before the policy date. So if any of this stuff exists, they have a duty to defend your title. This is the point. Your title insurance company, if you're in a foreclosure, right, should be sitting there. They should be your attorney. You shouldn't be going to hire an attorney. You did hire one. That's what their job is. Against actual loss, including any costs, attorney's fees, and expenses provided under this policy, right? There's some of the other interesting things on here. Someone else tries to enforce a covenant. A taxing authority assesses supplemental real estate taxes not previously assessed against the land. Right? Not against the real estate, the land. If it's not against the land, it's not a tax. A document upon which your title is based is invalid because it was not properly signed, sealed, acknowledged, delivered, or recorded. Right? If the paperwork's messed up, the title insurance company has to take care of it. Excuse me. The residence with the address shown in Schedule A is not located on the land at the policy date, and I believe that's probably what this is these are things that we've already talked about over a year ago, and I'm basing this right now on Bobby in Arizona's paperwork, and they don't have to this day. The house is, I think it was built 2002, 2003. There's no certificate of completion, and they won't give you one, right? So the house was never completed, and so I don't know that the address shows up in the proper map yet because the house is never completed. Okay, so they're going to defend your title and legal actions only as to that part of the action which is based on covered risk and which is not accepted or excluded from coverage policy. Will pay the cost, attorney's fees, yada, yada, yada. Okay, and this is, it's got the seal of the corporation on it. Countersigned by the secretary. Now this lists all the things that it doesn't cover, or so they say it doesn't cover. But any charge upon the land by reason of inclusion in a homeowners association, water rights, whether or not shown by public record. Well, how can there be claims or water rights, claims or title to water, whether or not shown by the public record? Well, if it's not on the public record, how can it be a claim or a right? Now, this one's really interesting. The right to enter upon said land and prospect for, remove all the stuff, right? As reserved in the patent to said land recorded in docket 1473, page 3. Well, docket 1473, that's a court. Courts use dockets, don't they? Docket book? That's where the land patent's been recorded. Right? And we need to go look at it, see if anybody has any rights on your property, but I bet you they don't. A deed of trust, right? A deed of trust. Bobby was the trustor. Who's the trustee? The title insurance company. Go figure. Yeah. So, they have a duty to defend your title. And somewhere here near it says you go to Section A to see what the level that is, and that's what we're going to do now. I need to start closing some of these up. We've got too many windows open. All right, this is the, this list of the exclusions. I don't want to get too much in. I'm not going to spend a lot of time on that stuff, but anyways, this is how you file to make a claim, right? So probably you should do this first, make a claim. What's your claim? Well, I don't have my certificate of title. All right, you should have either a certificate of title or abstract of title in your hand if they were defending your title, because as you'll see, so how to make a claim, right? On your policy, it's going to tell you how to do this. You're going to send a notice to this. So I would pay attention to how you properly do a notice, right? One kind of notice is a order to show cause. That's a hell of a notice. Hey, get in here and tell us why you're not defending this man's title. But here's Schedule A, and this would tell right, yada 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 yada. But what I really want to see is the estate or interest in the land which is covered by this policy is fee, F-E-E. Well, fee by itself can't be any less than fee simple. Whenever they start to add words to fee, they always put them in the beginning, right? So except fee simple. Otherwise, if it's less than fee simple, the word making it less goes before the word fee. So Bobby has a title in fee simple, which means absolute title, right? So where is his certificate of title? Where is his abstract of title? Because it depends on what state you're in. I think in Arizona they use abstracts of title. When he called the title insurance company, said, "Oh yeah, we have the abstract title, but we use that for our internal working." Well, that's his, right? That is your legal title. And so they have some work to do, because the other thing is, now, one of the list of things that was a covenant against Bob was something to do with the title, or with the school district. And so they had a donation agreement, and this agreement said that for every lot sold, there was going to be a donation of $300. Developer hereby agrees to pay to the district a donation of $300 for each single-family residential unit initially constructed on the property. Right? Well, if they never did that, right, then there's a lien against your property. And this paperwork for this was filed at the school district. And, we're going to be talking about school districts more, because it is a body politic, political subdivision, municipality. It could be where we're supposed to go register as voters and appoint them our agents and attorney in what would be known as a ward republic, the smallest republic there is. You got the federal government, you got the state, you got the county, and then you got subdivisions of the county, and what they should be are called wards. Republic. That was the idea that Thomas Jefferson had. And so a township, especially a survey township, isn't necessarily a local government. It's just a survey. It's 6 by 6 square, but a township, small t township, is is a district of land that is set up as a municipality, self-governing. And so are school districts. School districts can tax. That's one of the things about being in the government. You get to tax. And in Michigan, when you look at the Michigan's organizational chart. It's got the governor on the top, comes down, boom, breaks into 3 lines or 3 boxes under the governor. School boards, Secretary of State, Attorney General. Well, now, the school boards then would be like legislative. The Secretary of State would be judicial. And the Attorney General would be executive. 3 branches of government under the governor. And Roe found out in her school district, when they talk about a director, so they have a school board that gets elected. Then they have a director, a recording secretary, and a superintendent. And the superintendent is appointed by the board. But the director is called the governor of the district. And then you got a recording secretary. Well, that's what the Secretary of State does. And this supervisor that they hire, or basically they appoint by an election, is the Attorney General, in my opinion. It's a little government. It should be your little government. And it's where you should, right now it seems like we're considered federal U.S. citizens in residing in Michigan within a corporate county, where what we should be is citizens of the United States of America, being a citizen of the state of Michigan, residing in a ward republic, school district, township, city, boom. Now, you would think that cities are municipalities, but when you think about it, if you were to be driving through the city and you got stopped for speeding, right, are they going to give you a ticket for an ordinance infraction within the city or against a statute within the state? Right? Because for them to give you one with an ordinance, they would have to have a charter. Or if they don't have a charter, they're really not a city. That's why they don't say, like on the cop cars, city of Surprise, city of Greenville. It just says Greenville. Surprise Police, Greenville Police, whatever. Doesn't say city of, right? Then probably good chance that they're not municipalities. They're at best a special taxing district. So, okay, so let's say you're in a foreclosure, right? Go find this frickin' piece of paper. I wish I hadn't closed those things now. Shit, I hate when I do that. I had it open here, right? Go find this thing. A policy of title insurance, right? And figure out how to do a special action, special proceeding, whatever it is, asking for specific performance for the court to compel the title insurance company to give you specific performance to fulfill their contractual duties because, or obligations, because they had they got a duty to defend your title, to defend against legal actions. Right? But other things that they have to do is someone else owns an interest in your title. Well, clear it up, right? They need to cover these. These are things they're supposed to cover. You're supposed to have it in fee simple. And if there's anything hanging on to your title, you ain't got it in fee simple. And as far as your deed of trust that they're the trustee on, remember that on the note, promissory note, although it's probably just called a note, that as soon as the bank took that thing and paid to the order, they extinguished the debt. There is no debt. They're just trying to use it again to say, hey, man, you signed this thing, right? But as soon as you look at extinguishment of debt on Google, take you to Wikipedia, and you'll see that, one of the things that extinguishes the debt is when you I can't remember the word they use. I don't want to say that you give up the thing, but because or surrender it, because it isn't surrender. That's a different one. Well, first of all, if you surrender the note, the debt's extinguished. So if they can't produce for you the wet ink signature blue ink note, then the debt's extinguished. And remember, these things are multi-page documents, so make sure they give you all the pages. But the other one is if they substitute one form of security for this, you've given them a security, this note. It's a private note between you and them. They're going to take it and put pay to the order of. Fuck, Bob. They're going to take it and put pay to the order of on it. And trade it in basically for a higher form of security, one that's good for public and private debts, called legal tender, Federal Reserve notes. All right, I got to take this call. Sorry. All right, let's try to continue on. Maybe the phones won't ring for a bit, Lord willing. So in Michigan, we have a series of Michigan court rules, and these are all on PDFs, can be downloaded off the court website, state court website. And Chapter 3 is on special proceedings and actions. Chapter 2 is on civil actions, but these are special actions. And if we look up mandamus and we go to where it is, extraordinary writs, 3.301, extraordinary writs in general. A civil action or appropriate motion in a pending action may be brought to obtain superintending control, habeas corpus, mandamus, or quo warranto. Well, superintending control is like writ of certiorari. But it says you can do a civil action, which is to go start a. Now this is lowercase civil action. And again, I think that we're talking about things where you go to the county clerk first to get an index number and then go to the court to start the court case. And it may be different in every state, and so I haven't really looked yet at Michigan's. When I noticed that thing about New York, I said, oh, this is interesting. Went to the county clerk first. What I do know is that Rich here in Michigan in Alpena had a court case going on, and we were putting in complaints, and the judge was holding the complaint in his hand, and all sorts of things, man. They were really trying not to pay attention to it, but he finally ended up getting a lawyer, and the lawyer ended up putting in, basically one piece of paper, two different places. The county clerk and the clerk of the court happens to be the same person in two different offices. I wonder if, he went to the county clerk first, did something, got a piece of paper from there, and went and put in the court. I don't know. But I do know also in Michigan, it talks about when you search on the word chancery in the Michigan compiled laws, you can find them online, that one of the links is it talks about that when you have a court case going on, there's two separate files, one in the circuit court and one in chancery. And the one in chancery has anything to do with money, revenue in it. The financial instruments are in the one that's in chancery. They're not in the one that's in the court. Well, where's chancery, right? Where's the court of chancery? Well, I think it's the office of the clerk of the court. Or the office of the clerk of the county, excuse me. So we're going to try to find these things out. Like in New York, it was you go to the Supreme and County Court Clerk's office, but you're going to write a check to the office of the county clerk, which is different than county clerk. Right? The office of the county clerk isn't the same as county clerk. So let's look at something else, though. So, before we leave these special proceedings, the reason for doing these then are, if you have a ticket against you or some kind of criminal offense and there's no sworn complaint, because there isn't one, right? You want to get superintending control from a superior court, higher court, and superintending control. and have them take a look at the case and say, man, they're not, they don't seem to be following the law. Another interesting one here in Michigan, right? It says here that these particular other Michigan court rules in another book, Book 7, they apply to original proceedings brought to the Supreme Court and original proceedings brought to the appeals court. Like you don't have to go to the circuit court, the county court. You could go to the Court of Appeals, the Supreme Court. And when you appeal something, right, it's not a procedural error. You're going to say, I'm appealing a willfully false judgment or perjury of witness. That's what I'm appealing. And that's why you need superintending control from the higher court over the lower court. So, now another thing that we've talked about in the past are these business registration certificates. Some people call them DBAs. Some call them assumed names. They have all sorts of things, right? Talked about this earlier. Oh God, it was at the beginning of the summer, I guess. And we tried doing some. And I may have gotten some bad information at the time. The name of your business is your all caps. It is your business, right? It's a legal personality that was made up for you. It's yours. It's your business. All caps is yours. Your business. Take it. Who's the owner? Name a person's owning, right? Well, that's your natural person. So Robert Allen Rutluski, all caps, goes up here and give it the name of the mailing address, 10955 14 Road, Rockford, Michigan, 49341-8664. Right, that's the address of the business. How do I know? Because they send lots of mail to all caps to that address. Now, this is the name of persons owning, conducting, so this is the owner. Well, this would be my natural name, Robert Allen Rutluski, proper case. Same street, city, state, zip. None of that's changed. Right? If you want to get a hold of me, I live at my business. If it's a partnership, in other words, you were married, right? You would have to do one of these if you were married. Signature of all persons listed above. Boom, boom, boom. And when you subscribe and swear to it, when you do, right, that's how you certify to this. And then Mary Hollenrake is the clerk of the county. So office of the clerk of the county of Kent and of the circuit court thereof. Right? Office of the clerk of the county and of the circuit court thereof. Now, Roe was told by her circuit court clerk, Tom, when he says circuit, he really means county. And of the county court thereof. That's the court of record, right? That's where the records are kept, my opinion. Right? And that's when they're, when you see it this way and they're testifying, they're going to testify, they're going to put a big ass gold seal over here. Okay? Now, why would we might want to do this? I'm not hesitant to talk about this because either we do this or we go and register in a ward republic. But if you haven't done this is the main reason I want to point this out. We're going to go to the bad stuff, right? What if you haven't done this? Give me just a minute. Where are we at? Oh, hang on just a second. Okay, well, I really hope this works. Sorry for all the interruptions. And it's hard for me to concentrate when I get so many interruptions. Anyways, where was I? So this thing, the undersigned hereby certifies under the provisions of MCLA, Michigan Compiled Laws Annotated, 445.1, yada, 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 that the following person now owns, conducts, or transacts, or intends to own, conduct, or transact a business, or maintain an office or place of business in the county of Kent, state of Michigan, under the name, designation, or style set forth below. all caps, Robert Allen Vertluski. Business address, your mailing address. Name of the owner, Robert Allen Vertluski. Upper lowercase, proper case, residence address. Street, city, state, zip. Now they didn't ask for the street number. This is the interesting thing, right? Complete mailing address 10955. But what street do I live on? 14 Mile Road, Rockford, Michigan, 49341, I guess. Okay. Now, where was I headed with this? Okay. Now we want to go look at what the law says. So that very last part, 445.5, violation of act. Any person or persons owning, carrying on, or conducting or transacting business as foresaid, who shall fail to comply with the provisions of this act shall be guilty of a misdemeanor, and upon conviction thereof shall be punished by a fine of not less than $25, no more than $100, or by imprisonment in the county jail not exceeding 30 days, or by both. Such fine and imprisonment in the discretion of the court. So if you want to know why they charge you with contempt of court, 30 days, well, it's because you violated this act. And each day any person or persons shall violate any provision of this act shall be deemed a separate offense. So every day you wake up, you're guilty of a misdemeanor. Could be fined $25 to $100 and 30 days in jail, because you haven't registered that you're doing business as somebody other than your proper name. Right? Your all caps is the name of a business, and it's your sole proprietorship. And in a sole proprietorship, the business is treated the same as a natural person, so if the sole proprietorship, the business gets in trouble, it reflects back directly on the officer, sole proprietor of the business. Where in a corporation, if a corporation gets in trouble, there's a separation between the corporation and the officers. But we have sole proprietorships. Provided, however, the fact that the penalty not to provide, non-compliance, provision of this act shall not be construed to avoid contracts. So you can't say, well, the contract was avoided because I hadn't signed. No, we're still going to hold you to the contract. Any person or persons failing to file a certificate required by Section 1(1)(a) shall be prohibited from bringing any suit, action, or proceeding in any of the courts of this state in relation to any contract. Until you do this, you cannot have access to the lower S state courts. Well, to me, it sounds like this is a statute being used as an instrument of fraud, right? Because they're going to keep you from having your property. Or any other matter made, done by any person or persons under the assumed or fictitious name until after full compliance with provisions of this act. So one of the things is, okay, if this is the case, if I'm guilty of a crime for not doing this, and I go sincerely trying to do this at the county and they don't do it properly, they're guilty of a crime. They're aiding and abetting a criminal. Right? Or they're guilty of obstruction of justice. But no persons or persons doing business under a fictitious name or as the assignees thereof shall maintain or prosecute any action, nor shall any order, judgment, decree be made in any action heretofore or hereafter commenced in any court of the state upon any account of any contract or contracts made or transactions under which a fictitious name after August 14, 1999. Till we do this, we're not going to get any relief, is what this law is written to say. If the conduct of such business under such fictitious name has ceased, or if it is still conducted under such fictitious names, then until after full compliance with the provisions of this act, this all goes together. So, if the conduct of such business under such a fictitious name has ceased, well, how would that happen? The conduct of such business. You could move, be one thing, or you could die. See, and I think that the death certificates for our ancestors, right, have not been recorded in a proper office. They need to go to this office of the clerk of the county court. Office of the clerk of the county. The clerk of the county court to make it a court record that they've died. And until then, they're just considered a decedent, just like we are. We're either considered decedents, or as we're going to see in this, we've just abandoned our property. Whenever an assumed name concern shall go out of business, it shall be the duty of the persons or persons who have conducted such business to file a certificate with the clerk of the county or counties in which the concerned transacted business of the discontinuance of the operation of the business. Sounds like a death certificate. Now, that's the end of it. Let's go back to the beginning. So how are you supposed to do this thing? And why would you do it? Well, Section 1. A person shall not carry on, conduct, or transact business in this state under an assumed name or under a designation, name, or style other than the real name of the person owning, conducting, or transacting the business, unless the person files in duplicate in the office of the clerk of the county in which a person owns, conducts, transacts, or intends to own the business a certificate on a form furnished by the county clerk setting forth the name and under which the business is owned or is to be conducted or transacted, and the true or real full name and address of the person owning, conducting, or transacting the business. So your real or full name is, your true or real full name is your proper case name. And if you have an uppercase, well, that's a different style, and therefore you have to do this form for that simple reason. You have an uppercase legal personality that you're doing business as. It's a business, and you haven't registered as the owner. And when you register as the owner, then the mail that needs to come to you can come to you. At the time of filing the certificate, the person shall pay the clerk a filing fee of $6. The certificate shall be executed and duly acknowledged by the person owning, conducting, or intending to conduct the business. At the time of filing the certificate, the person shall pay the clerk a filing fee of $6. Okay, so first of all, they're going to file in duplicate in the office of the clerk of the county a certificate on a form furnished by the county clerk. Well, this could be the form right here, and they want you to do it in duplicate. And so this is what's going to make it a certificate, is when you swear and subscribe to it, because it says up here that the undersigned hereby certifies under the provisions of whatever, yada yada yada, right? So to make it a certificate, you're going to do up to this part right here where it says my commission expires. And that should have made it a certificate. You need to do it in duplicate. Okay, I got 2 copies. Now what do I do? What's next? Where we go next? Okay, pay $6. But this is at the office of the clerk of the county, not the county clerk. The office of the clerk of the county. Right? So if I was in Michigan, I'd be going and say, well, it looks to me, and I would take this with me and point to it and say, it looks to me like I start by going to the office of the clerk of the county. Is that you, whoever you're talking to? No. Well, then who is it? Where is the office of the clerk of the county? The county clerk shall certify the duplicate and return it to the applicant. So they're going to take 2. Okay, you're going to give them a duplicate, and then they're going to certify the duplicate, and that is where they're going to do this. I, Mary Hollowright, clerk of the county of Kent and the circuit court thereof, do hereby certify the foregoing as a true and exact copy of the original document on file in the office of the county clerk. Okay. You need to do this every 5 years. If you don't do it every 5 years, well, then, you're going to abandon your business. It cost you $4. The thing is, between the 16th and 30th day of that 5-year period, they're going to send you a blank form. The failure to file that renewal and pay the $4 before the expiration constitutes abandonment of the assumed name. you will have abandoned your property. So myself, I'm not going to wait and do it every 5 years. I'm going to do it every birthday. It's my birthday present to myself. Go down there and fill it out. The notice required in the act shall be mailed by the county clerk to the last address of the person or persons whose certificate will expire as stated on the original or renewal certificate. Well, if they're sending you a renewal certificate, shall mail to the person or persons whose certificate will expire renewal certificate blank forms. Well, the forms are going to be blank, so they're not going to know who to mail them to. That's the way it looks to me. Right? Above said the form would be blank. So we hope they use the original, but what if they decide to use the renewal? I'm not going to let them have the option. I think I'll just do it every year myself and go down there and do it. Okay, so now, we've had it filed. Now, assume name changes. These are some of the other little things, but I don't want to get too much into them. I want to get down to this thing here. Okay. The county clerk shall keep an alphabetical index of all persons filing certificates provided in this act, and for the indexing and filing of the certificate shall receive a fee of $10. A copy of the certificate duly certified by the county clerk, in whose office the same is filed, shall be presumptive evidence in all courts of law in this state of the facts contained in the certificate. Upon the payment of $10, the payer shall be entitled to 2 certified copies of the certificate without extra charge, with additional copies of $1 each at the time of filing the original certificate. So this is the lowercase county clerk. It's not the uppercase county clerk. I think you're still with the same person when you were in the office of the clerk of the county. And now we need to have it indexed, right? So this is where that index file comes in. They maintain an index. And they're supposed to charge you $10 to index it. So this isn't done with the county clerk. It's done in the office of the clerk of the county. And I think that becomes the lowercase county clerk. Right? They're going to keep an index of all persons filing certificates. Okay, well, I filed a certificate with them. Now they're supposed to go index it and charge me $10. So I'm going to get charged $6 the first time, get it certified. What page is this? This is page 5. What did it say? At the time of filing the certificate, the person shall pay the clerk a filing fee of $6. So I'm going to pay $6 to file it, and then $10 to have it indexed. The county clerk shall certify the duplicate. Okay, so whoever certifies it and gives it back to me, this is step 1, right? So we go back to this. We did this in duplicate up till here. My commission expires. We went to the office of the clerk of the county and paid them $6, and they did their thing, and they're going to certify the duplicate. So on the duplicate, they're going to do this bottom part and put a seal right there. Okay, I have that now, but what I don't have is it hasn't been indexed. And it looks like that's done with the same clerk. Same office. So I would be asking these people, now, are you the office that indexes this per section? That's why you take the law in with you. Because who's going to remember all this crap? Per section 445.3, where it says the county clerk shall keep an alphabetical index. A copy of a certificate duly certified by the county clerk in whose office the same is filed. Is that what this is going to say? Therefore, do hereby certify the foregoing is a true and exact copy of the original document on file in the office of the county clerk. That's beautiful stuff. And it shall be presumptive evidence in all courts of law in this state of the facts contained in this certificate. And not only that, you'll have found the correct office from then on to bring your complaints and so forth to, because we're dealing with the Court of Chancery, in my opinion. And so if we don't do this, right, then We can't have access to the state courts, and we can't have any relief on any contracts. Now what happens? Okay, so that's step one. This is a multi-step thing, but let's say we got that done. And now we're going to get some certified copies. I'm going to have 2 certified copies of the certificate without extra charge, with additional copies of whatever. So you'd have copies to go put in a court case if you needed to, and you'd know where to go get them if you needed them afterwards. If 2 or more persons file assumed name, the certificate shall be prima facie evidence of a contract of a partnership. Man, more interruptions today than I know what to do with. All right, so then it goes on to say, okay, so then every person who is a non-resident of the state, upon filing a certificate provided in this act, shall file an irrevocable consent that actions may be commenced against the person in the courts of this state by service of process or pleading authorized by courts of law in this state on the county clerk in whose office the certificate and consent were filed. For filing of the consent, the county clerk shall receive a fee of $2. Okay, but they're talking about service of process, and these are one of the things that we need to do. That's part of having a registered agent, is so that service of process can be served. The county clerk shall keep a record of each process and the date and hour of service. Now, this isn't necessarily just for the out-of-staters. This is for anybody. Notice of service and a copy of the summons shall be immediately either be served upon the defendant personally by the sheriff or constable of the county in which the defendant resides, or sent by certified mail by the plaintiff or the plaintiff's attorney to the defendant. This is the county. Now again, this is the county clerk sending you that you've been served papers, right? When you get served papers by anybody, does it say it came from the county clerk's office, or did it say it came from the clerk of the court's office? They're saying the county clerk is going to serve you. The circuit court of the county, in the office of the county clerk. Where's the circuit court of the county? It's in the office of the county clerk, of which the certificate is filed, shall have jurisdiction of an action brought against the non-resident person, but this provision shall be construed as depriving other courts of jurisdiction. The circuit court. One guy in Rose, circuit court clerk, said circuit to him means county. The county court of the county in the office of the county clerk. Sounds like that's where the court is. The certificate referred to in Section 1, for any person that is named in the certificate and not an individual, shall state the nature of the entity, the statutory law, yada, yada, yada. Basically, this is saying, right, that all these companies that come after you, corporations, they're supposed to have a doing business an assumed name also. Right? Your plaintiffs that come against you. Violation Act. Okay. Here's my problem. Our old courthouse went down, but in counties of Wayne and Kent, that's one I'm in, the county auditor shall provide suitable office for the use of the reporters or recorders contiguous to the office of the clerk of the county. So I can find the county auditor, although you can't find them online. They don't use that word. Because I was trying to determine where is the office of the clerk of the county. Now Heather Lee up in Suttons Bay, Michigan, talked to the clerk up there and had mentioned these things to her, and the clerk, it sounded like the county clerk said, yeah, that was her office, and she wears many hats. And she gets involved in all sorts of things, and some to do with probate. A lot of the right little tidbits were being said, and, you know, I'm doing a lot of this so Heather can go to the next step and go talk to the clerk and say, look, is this you? Is this where I bring this form to? right? Because if I don't do this properly, then I'm guilty of a misdemeanor, and that would make you guilty as an accessory. Or you're obstructing justice. So let's just please do it correctly. A county auditor shall meet, transact business in the office of the clerk of the said county. Auditors is a ecclesiastic term. I guess that's why I had those in here. Shall be the duty of the sheriff of every county to keep an office at the place where the courts for such county are held, of which he shall file a notice in the office of the clerk of the county, and keep the same open during the usual business hours each day, Sundays excepted. In a lot of places, they're not using the old courthouse for the courts that we go into. You know, the old courthouse is there. That's where the county clerk is, register of deeds, that kind of stuff. But if that's the seat of justice, and that's where the county court is, then the sheriff has to keep an office there. And it doesn't have to be 10-star sheriff. It's the English sheriff, the one you would take your complaints to, basically the king's top businessman. Interesting. Chief deputy sheriff filed in the office of the clerk of said county. Right. So again, this is determining where the office of the clerk of the county is. It's the goofy stuff. Look at it. Take the oath prescribed in the 12th article of the Constitution of this state. Well, in the current, you know, this is off of today's website for Michigan compiled laws. It isn't in the 12th article of the Constitution. That would have been like the one in 1908. The 1963 Constitution, it's Article 11. Right? So I don't know what to make of this. It reads the same, but it's like they're using a different Constitution. Because the one in the 12th article isn't the 1963 Constitution, the most current Constitution. A person who is not registered to vote at the address where he or she resides may apply to register to vote by submitting an application at any of the following locations: the office of the clerk of the county, or the office of the clerk of the city or township in which the applicant resides during regular hours of the clerk. See, we really want to be a registered elector. I don't want to register to vote as much as register to elect. And I have seen it before where they talk about registered electors. I was just pointing out things I do with the office of the clerk of the county, because when you find this office, there's many things that happens there. If this is the office of the county court are, and I believe still are, the naturalization courts. Well, if they're naturalization courts, they are actually part of the federal government also. And at these county courts, you used to go and take your oath of allegiance and get a certificate of citizenship. And it would make you a citizen of the United States of America. Not a U.S. citizen, but citizen of the United States of America. This is where all the records are going to be. All the things that we really need to know are in the county court. And we need to find the office of that clerk. If the vacancy is the office of the county clerk if the vacancy occurs in a public office, the vacancy may be filled by appointment by the governor. Otherwise, notice of vacancy, the facts of the vacancy exist, shall within 10 days from the vacancy occur be given, yada yada yada. Vacancy is in any county office except for the county clerk by the clerk of that county. The office of the circuit judge or recorders of a city court by the clerk of the county. If the vacancy is the clerk of the county, by the judge of probate. Lots of reasons offices could be vacant, right? One of them is they're vacant because the guy holding the office hasn't taken the proper oath. And I pointed this out numerous times. You can see where it says they're supposed to take the oath in Article 11 of the Constitution. In that oath, there's no place for you to put your name, right? Not I, Robert Allen Rutluski, yada yada yada. Just I, yada yada yada. And there's no "so help me God" on the end, right? There's no religious test to it. Well, if they haven't taken that oath, then they haven't taken the proper oath prescribed in the Constitution. They're not holding the office. And when you look at, and so the people in the township are those that should have taken this oath that's in Article 11 of the Constitution. But when you look at their oath, it goes on and on and on with all sorts of dribble in there. Right? They have not taken the proper oath. They're not holding a state office. Now, at the time, I thought, okay, because they're called I was thinking that the townships... I was thinking that the townships were unincorporated federal districts, and therefore they would be federal. And I had sent a complaint down to the circuit court clerk of the 6th Circuit Court, federal level. I think they're down in Kentucky. Complaining and asking for superintending control over the township because they hadn't taken the proper oath. And they did answer me back and said, well, it seems like this would be a state issue or something like that. I don't remember what it was. Not really the answer I wanted. I kind of went on from there. But now, seeing that I could do an original action into the Supreme Court of Michigan, I may do the same thing because they haven't taken the proper oath. They're usurping the office. Yeah, Section 1, Article 11, 1963. That's where the oath is. And I don't know if I had anything else in here. Here it is. I do solemnly swear or affirm that I will support the Constitution of the United States and the Constitution of this state, and that I will faithfully discharge the duties of the office of, according to the best of my ability, period. No other oath, affirmation, or religious test shall be required as a qualification for any office or public trust. Public trust. Who's the guardians of the public trust? The school districts are. Interesting. Oh, what else did I want to go through? I think that was all of those. I'm going to shut this off one more time since I've done so many so I can regroup. I'll be back in a second. Okay, just a few more things. I'm going to call this one done, but I wanted to point some things out. What is a registered office? A registered office is the official address of an incorporated company. Now, it depends on what the definition of incorporated means. One of its definitions is to be incorporated means to be registered. Right? When was your company registered? When was All Caps registered? Mine was about 13 days after my birth. I was born on September 5th. The local registrar received the certificate of live birth on September 18th. Received by a local registrar. Registered on the 18th. That's when my business went into effect. Generally, it will form part of a public record, and is required in most countries where a registered organization or legal entity is incorporated. Registered. A registered physical office address is required for incorporated organizations to receive official correspondence, formal notices from government departments, investors, banks, shareholders, and the general public. All right, so you can't get this mail unless you have a registered physical office. And as I've said before, I don't think we're getting the mail. It's going to lost mail. And I think this is why we don't have a registered office. In many other countries, the address with which a company is registered must be where its headquarters or seat is located. And this will often determine the subnational registry at which the company must be registered. Okay, so the address in which the company is registered must be where its headquarters or seat is located. Well, I'm going to say it's right here where I'm at. And therefore, I need to register it in the subnational registry. Well, what does that mean? I'm going to say the company's already been registered. What hasn't been registered is that I'm the owner and given it a registered address yet. And so this is where you need to do this in this county, right? That's doing the DBA is you registering your corporation, your sole proprietorship, so that you can get the mail. A registered physical office address is required for incorporated organizations, registered organizations, to receive official correspondence and formal notices from government, departments, investors, shareholders, and the general public. There's one other. Okay, that was the main thing on that one. Registering as the owner. In Michigan, you can establish a sole proprietorship without filing any legal documents with the Michigan state government. There are 4 simple steps you should take. Right? You're not going to do it with the Michigan state, you're going to do it at the county. Choose a business name, file an assumed name certificate with the county clerk, obtain whatever licenses you need, and obtain employer identification number. But why would we want to do this? Okay, so let's go through this. So we're going to choose a name. It's your all caps. File an assumed name certificate. This is mandatory requirement in Michigan. Can't get around it. They want you to do it. Right? If you're doing business under a different name, then as you can see, I mean, just doing it under a different style was enough reason in Michigan they want you to do this, and you need to renew it every 5 years. Obtain licenses, permits, and zoning clearance. Right? Depends what your business is. One question is, it could be banking, because if you watched my video on elements of a check, right, the name of the bank goes at the top of the check. What's the name at the top of the check? Your name is. Makes you the bank. Could be that we're just property owners, right? Don't really know yet. I'm going to have it as broad as possible, say as little as I need to. Okay, obtain employer identification number. Well, you could use your social security number. Wish to have employees, right? If you wish to have employees, you have to have an EIN number, right? Well, I don't want to have any employees, so I'm not going to worry about it. Even though sole proprietors without employees are not required to have an EIN, you may want to attain one anyway. Some banks require one to open a bank account. Right? So you may have to get one to open a bank account. Okay, and then you need to register your business to report taxes through the Michigan Business One Stop, which is like, you getting a hold of the revenue agents. But here's the important things. Then you want to open up a business bank account. And you want to get general liability insurance, because sole proprietors are personally liable for all debts and obligations of a business. A business liability insurance policy may be the only form of financial protection against unforeseen events. Then you're going to report and pay your taxes, right? So you need to register with the Michigan Business One. But what is this general liability insurance? What's it do? Cost to defend or investigate a suit or claim against the insured, including court costs, witness fees, attorney fees, and police report costs. So now when somebody charges your all caps, you turn it into your insurance company. So here, you're my attorney, right? They tell us we need to hire an attorney, right? Well, there you go. This covers the attorney's fees. People have been told numerous times, go hire an attorney. Well, if you had business insurance, you would be hiring an attorney. And what's the other thing? A premium for a bond that ensures you can satisfy a potential judgment in a liability suit if required, right? You're going to be bonded and insured. And you're going to have an attorney. So if you had this bond set up correctly, right, theoretically, you shouldn't need like car insurance or home insurance or health insurance or nothing else. You just get some kind of umbrella under your business liability insurance to cover all that stuff. I'm not an insurance expert, but I'm sure you can do something like that. I read, I don't think it's on this thing. Yeah, it was on something else that I was going to show and I forgot where it is. But it said that in Montana that you could get a surety bond. in place of auto insurance. Okay, well, it says Montana. It probably says it in every state. I just happened to find it for Montana. When I was looking for the office of the clerk of the county and just searching on that, I came across it. Legal personality. To have a legal personality means to be capable of having legal rights and duties within a certain legal system, such as to enter into contracts, sue, and be sued. Legal personality is a prerequisite to legal capacity and the ability of any legal person to amend, enter into, transfer, etc. rights and obligations. Legal personality are of two kinds: natural person, being people, and juridical person, artificial, fictitious persons, groups of people such as corporations, which are treated in law as if they were persons. While people acquire legal personhood when they are born, juridical persons do so when they are incorporated, which was registered in accordance with law. Juridical persons, artificial personality, juridical personality, legal entity, juristic personality, characteristic non-living entity, regarded by law as having the status of personhood. A fictitious person, artificial person, juridical person, juristic person, legal entity, body corporate, also commonly called a vehicle, has a legal name and has certain rights, protections, and privileges, responsibilities, and liabilities under law similar to those of a natural person. Your legal name is your all caps. Legal personality allows one or more natural persons to act as a single entity for legal purposes. In many jurisdictions, legal personality allows a composite to be considered under the law separately from individual, yada yada. They may sue or be sued, enter contracts, incur debt, own property. Entities with legal personality may also be subjected to certain legal obligations, such as payment of taxes. An entity with legal personality may shield its shareholders from legal liability. The concept of legal personality is not absolute. Piercing the veil refers to looking at the individual natural persons acting as agents involved in corporate action or decisions. So maybe we get to be our own agents when we have registered our business to show that the owner that there is an owner to the business, that it has not been abandoned. We have abandoned, or all caps. Some example of legal persons are their sole proprietorship and corporate sole. I'm not really sure which one we should be. Corporate sole sounds pretty good. That's what the crown is. That's what bishops are. That's what municipal corporations are. Well, I got to show you one more thing. I got to go find it. This is okay. In Michigan, Michigan Compiled Law 45.3, County Body Corporate Purposes, each organized county shall be a body politic and corporate for the following purposes: that is to say, to sue and be sued, to purchase, to hold real and personal estate for the use of the county, borrow money, repair county buildings, yada yada yada. So in the county, the organized county is part of a body politic, body corporate. What do they consider county property? All real and personal estates heretofore conveyed by any form of conveyance to the inhabitants of any county, yada yada yada, shall be deemed to be the property of such county. The property of the inhabitants is the county's property, right? If you're an inhabitant, if you're considered an inhabitant of the county, then your property is the county's property. However, in MCL 41.2, this is on townships, inhabitants of organized townships, of an organized township, are a body corporate. Right? So up here, you were nothing. Your property was the state's property, and the body corporate was the county. In an organized township, you're a body corporate, and have, in addition to other powers, those that are confirmed with the following powers and duties: to sue and be sued, and to appoint necessary agents and attorneys for that purpose, to make contracts necessary and convenient to the exercise of corporate powers. The supervisor of the township board, by majority consent of the township board members serving, may serve upon person a subpoena. Right? So, who's going to bring you the service? The township is. A suit, act, or proceeding by or against the township in its corporate capacity shall be in the name of the township. The supervisor of each township shall be the agent for his or her township for the transaction of legal business. Well, this just said up here that I could appoint necessary agents and attorneys. I want to appoint the township supervisor as my attorney. I tried that. He about blew a gasket. Then I read his oath, said, oh, wrong dude anyways. This is not. This township hall is an illusion. The inhabitants of a township have the power, by vote of the registered electors of the township, to grant and vote sums of money, not exceeding the amounts limits by law, that they consider necessary for defraying proper charges and expenses arising in the township. The township board or a township officer shall not create a debt or liability against township or issue warrants, a certificate, or order of payment of the money, unless the creation of the debt or liability or the payment of the money has been authorized by the vote of the registered electors of the township or by law. Well, since we can't find the registered electors, I don't know that they ever paid the debts of the township, and that's what put liens against the inhabitants of the township, because we're the body corporate in the township. And so they put liens against our estates because the electors haven't gotten together, the registered electors of the township, to tell the treasurer to pay the fucking bills. Local government means any political subdivision of the state, including but not restricted to, very first one, school districts. Cities, villages, townships, charter townships, county, blah, 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 blah. The next video is going to be about school districts and why I think that it is the elemental republic that we're supposed to be part of, and the superintendent is your attorney general. The recording secretary is the secretary of state, and the director is the governor of the district, that little republic, however big it is. More on that later. We'll see what people have come up with. But so it could be, what came out of all this? Well, number one, if you're in a court case, you may want to consider trying to do some kind of special proceeding, special action, asking for a writ of mandamus, ceratoria, whatever it is. And I don't even think you need to ask for it specifically, and we'll get into more detail on this maybe in another video. But the point is, most of you guys understand this. You're putting in a petition complaining. The thing is, the petition needs to go to the right court, and the only court that petitions go to is the Court of Chancery, and it's the Court of Chancery that issues the original writs under the Great Seal from the Court of Chancery, such as a writ of mandamus and so forth. Well, when we find the Court of Chancery, we have found the Court of Justice, and that's where all the frickin' paperwork is that's keeping us in this frickin' box, because whatever is in the office of the recorder in the record is what they're going to use against you. And we need to change the presumptions that are in those records. So one of the things you may have to do is register a DBA, because it says that, if you're going to do business in the county, that you have to do this. But it could be that you go register as an elector and become a school elector in a school district, appoint the superintendent your attorney, and have him do it. And then you've hired an attorney. Basically, the superintendents are, the school board is elected by the local people, and they work for free. And then they get together and they hire a superintendent. Okay, they're hiring an attorney. The school board represents the other electors, right? So all the electors have hired this attorney through the school board. All right, you hired an attorney, go use them. And if they want to sue you from now on, whatever somebody wants to do, right? If it was supposed to have gone through the right, if you were supposed to have been served by the township supervisor, well, now you're going to have to, and again, this township isn't the survey township. It's a civil township. CIVIL, civil township. Whatever it is. If it exists, you know who knows? The office of the clerk of the court. The office of the clerk of the county. The office of the clerk of the county. And I'm going to pull those things out. Again, these are already done in a video before when we talked about township stuff, about becoming a registered elector, and if the books weren't at the township where you were supposed to go to find the registration books and so forth. It was the lowercase county clerk or the office of the clerk of the county. And I believe it to be the same person wearing those hats. And, that's where we're going to have to find our relief, our remedy. And we're going to keep looking at this school stuff. In fact, Ro was out today, going to go maybe talk to the school board. I haven't had a chance to talk to her yet. We'll see what she came up with. But that's it for now. I hope I didn't confuse anybody. If I did, I apologize.